torts, strict liability, and the prevention of dangerous activities. Strict liability is intended to protect society by preventing certain dangerous activities. Defendants undertaking these dangerous activities are held liable for the resulting damages, regardless of whether the defendant was acting in a careful, reasonable, or prudent manner. Strict liability is liability without negligence or fault. In a strict liability case, care is no defense. The defendant is liable regardless of whether he took reasonable care. Strict liability applies in situations where danger is unavoidable, even with application of due care. Most common strict liability rules involve wild and dangerous animals, unnatural land conditions, defective and dangerous products, and abnormally dangerous activities. Strict liability applies to wild and dangerous animals. A domesticated animal like a dog that's not known to bite is not considered wild or dangerous, so a negligence standard is applied to dogs that are not known biters. After a dog's bitten once, it's considered dangerous, and the owner of the dog is strictly liable for all subsequent bites. The owner is on notice that the dog is dangerous. Therefore, the owner has a responsibility to act to prevent future bites. The owner is liable to pay for all the costs resulting from the dog bite, regardless of whether the owner took care to prevent it. Farmers are held strictly liable for damages caused by trespassing cattle, and the owners of wild animals are held strictly liable for all damage they incur. Society wishes to prevent individuals from owning and keeping tigers, lions, hyenas, leopards, bears, and other wild animals that could pose a risk. Nuisance is one of the oldest causes of action known to the common law, with cases framed in nuisance going back almost to the beginning of recorded case law. Nuisance signifies that the right of quiet enjoyment is being disrupted to such a degree that a tort is being committed. Owners of real property, either landowners or tenants, are entitled to the quiet enjoyment of their lands. If a neighbour interferes with that quiet enjoyment, either by creating smells, sounds, pollution, or any other hazard that extends past the boundaries of the property, the affected party may make a claim in nuisance. Nuisance applies to non-trespassory interference. This means it does not apply to situations where people or tangible objects are entering the land. The tort of trespass would be used in these situations. So if a neighbour moves into a residential area and converts his home into a pig farm, the surrounding neighbours can claim compensation for the interference caused by the smells and noises emanating from the new piggery. Nuisance can trigger strict liability. The prudent and careful conduct of the farm owner will act as no defence. If the damage was caused, liability will attach, regardless of the care taken by the defendant farmer. We wish to prevent dangerous products entering the market, so merchants selling defective products are held strictly liable for resulting injuries. In addition to making claims based on theories of negligence, breach of contract, breach of warranty and fraud, customers injured by products can bring lawsuits based on strict liability against merchants. A merchant is a retailer or other entity routinely trading in this type of product. Private sellers and service providers are not merchants, so are not held strictly liable. A manufacturer, distributor, wholesaler, these are all merchants in the chain of distribution and can be held strictly liable for injuries sustained by dangerous products. Liability is not restricted to the retailer that sold the product to the customer. renters of products can also be held strictly liable. So in the case of a defective, dangerous car, the manufacturer, distributor, dealer, and the rental company hiring the car to the customer can all be held strictly liable. The product must be defective. A manufacturing defect affecting one unit or several units would qualify for strict liability. Design defects affect all the units. The design is defective if there is an alternative design available that's safer, not significantly more costly, and equally practical. The products lacking clear, prominent, effective warnings of inherent danger are deemed defective and strict liability results. The third element of a strict product liability claim is foreseeable use. Regardless of whether the use by the individual is what was intended or common, the question is whether the use is foreseeable. If the plaintiff used the product in a way that could be foreseen, then the merchant can be held strictly liable for the resulting injury. Abnormally dangerous activities result in strict liability. Injuries caused by ultra-hazardous activities, such as the use of explosives, chemicals, nuclear energy, radiation, all result in liability for the defendant, regardless of whether care was taken by the defendant to prevent injury. Ultra-hazardous activities can be identified as they are uncommon in the area, pose a severe risk of harm, and they cannot be performed safely. They are the type of activities that cannot be made entirely safe. As strict liability means liability without fault, there are very few defences. Comparative fault is the only defence available in many jurisdictions. Assumption of the risk, a traditional defence, is now incorporated into the comparative fault doctrine. If the injured plaintiff contributed toward the injury, then the liability of the plaintiff reduces the damages payable by the defendant. The defendant is strictly liable. However, the behaviour of the plaintiff can be taken into consideration to reduce the amount the defendant is forced to pay.